Good afternoon, Mr. Lekhuleni.
Good afternoon, ACJ.
How are you this afternoon?
I think I'm good.
Good.
Thank you.
Welcome to this session of the Commission's interviews.
Yes.
And thank you for making yourself available for consideration for appointment as a judge to the Western Cape Division of the High Court.
Thank you, Acting Chief Justice.
I see that you have quite a string of degrees. You've got a BProc degree, LLB, 2 LLMs, and an LLD. And I understand, I can see you are doing a third LLM.
That's correct, ACJ.
Yes. And you obtained your BProc in June 1992.
That's correct.
And then you obtained your LLM before you obtained your LLB.
That's correct.
You obtained your LLM in September 2004.
That's correct, ACJ.
And your LLB in September 2008.
That's correct, ACJ.
And your LLD in September 2012.
That's correct, ACJ.
And the second LLM in April 2016.
That's correct, ACJ.
Yes. But you also served your articles from 1992 to 1994, is that right?
That's correct, in Polokwane, Peters, which was then known as Petersburg.
Yes. And then after that, you were a legal advisor to Ikageng Legal Course. Is that right?
That's correct. After completing my articles, I was still writing the board examination, and I went to work for Ikageng Legal Course assistant as a senior legal advisor.
Yes. And then you worked as a public prosecutor?
That's correct, in Bushbuck Ridge,
yes.
where I come from.
And you practiced as an attorney for James Lekhuleni attorneys from February 1999 to 2004, is that right?
That's correct, until the 31st of October 2004.
Yes.
Yes.
During your time when you practiced during that period, what types of cases did you handle in your practice in terms of different branches of law?
Yes, thank you, ACJ. I was privileged to do different types of cases. I did civil cases, I did criminal cases, and I also had an opportunity of doing labor matters. And as you'll have seen, before I became an attorney, I went to work for LegalWise as well. And after working for LegalWise, I left and I went open my practice, and they gave me a lot of instructions. Mm-hmm. In fact, I was their own attorney, if I remember correctly. I was the only person who was doing their cases in Polokwane. Now they had a variety of clientele, and I had to do all their cases, and that exposed me to different fields of law: civil, criminal, divorce matters, and labor law.
Mm. Okay. And during that time, did you appear in court and did your own trials yourself and argued matters
yes,
by yourself?
That's correct. In fact, I was almost in court every day. I appeared in the district court, the regional court, and of course in the high court I briefed counsel, but I also appeared in the labor court.
Yeah.
Yes.
And then you served for some time as a reserve force military judge.
That's correct. When I was an attorney, I went to study military law at Tabatswane School of Military Justice, and I got an opportunity to act as a military judge in Limpopo, Nelspruit. Yes, that's correct.
And you were appointed an additional magistrate in November 2004, and that went on until sometime in 2013.
That's correct. In fact, yes, I was appointed district court magistrate in Cape Town on the 1st of November 2004, and I then acted in the regional court since 2010, and up until I was permanently appointed in 2013.
And you acted as a regional magistrate from July 2010 to October 2013. And then you were appointed as a regional magistrate from November 2013 to date.
That's correct. When the regional court was given civil jurisdiction in 2010, the then regional court president called me because of my civil court experience to the regional court, and up until that I was appointed in November 2013, yes.
And how much civil work have you done as a regional magistrate?
Yeah, as a regional magistrate, I did various types of cases. I did contractual dispute, I did delict, I did default judgments. I did various cases. I must say that I was not even confined in one place. As I've indicated, I was called to the regional court to implement the civil jurisdiction. In fact, I did cases all over the Western Cape. All over the Western Cape. I was not only confined to Cape Town, and that gave me a very good exposure to civil matters.
Yes. And you have acted as a judge in the Western Cape Division.
That's correct. In fact, I've acted consecutively from October last year, the last term of 2020, and I'm still acting even this year, even in this term.
That must have been given you quite a lot of experience, because it means that you are about to finish the fourth term acting.
That's correct, ACJ. It gave me a very wealth of experience and a wealth of knowledge to act in the High Court. As you'll understand that the jurisdiction of the Magistrates Court is a bit limited. Some of the cases you don't get exposed to, you don't get to do them because the magistrate of, the jurisdiction of the Magistrates Court is a bit limited. But in the High Court, I got to be exposed to different types of cases. I had happened to do constitutional matters. At some point, I was also exposed to administrative law matters, which I never had an opportunity to deal with them in the Magistrates Court. And it really, really gave me a very good exposure to various fields of the law.
Okay. Judge President.
Thank you very much, Acting Chief Justice. Dr. Lekhuleni, you have acted in the Western Cape for a while.
That's correct.
Let me ask you one question. What is your understanding of the rule of law?
Yes, JP, the rule of law, in my view, it indicates that the law is supreme, the law is sovereign, and there's no one who's above the law. In fact, the rule of law is one of the founding values of our Constitution. When you look at Section 1E of the Constitution, it makes it very clear that the Republic is founded on the supremacy of the Constitution and the rule of law. In my view, the rule of law entails that the law, it's sovereign, and we are all equal before the law. And it also echoes the provisions of Section 9(1) of our Constitution, which provides that everyone is equal before the law, and that we all enjoy the right to full benefit and protection of the law.
Just one last question, CJ. One of the problems that we have in the High Court, and you should know this as a judicial officer and someone who has acted as a head of court,
Yes.
is forum shopping.
Yes.
Lawyers, especially white male advocates, run away from certain judges, especially those judges who are not white.
Yes.
How can we deal with this in a real effective manner, and how can we eliminate it?
Yeah, I think it can only be dealt with in the allocation of the cases. In my view, it's very important that the attorneys or advocate need not know who's going to be allocated a case on a specific date. As the head of court, let's say for instance, me as the head of court acting in the regional court, I'd ensure that if let's say for instance I have to allocate cases, the members of, let's say the people who will be appearing before a particular magistrate, they will not know who the magistrate is going to be, who's going to take that dealing with the matter. And I think the same thing should happen like we do in the High Court. that advocates don't know who is going to be presiding in the matter, because if they know who's going to be presiding in the matter, if it's me, they will say that, no, look, the matter is settled, or they will say that, no, look, we're negotiating settlement. But if it's another person, look, if it's maybe a person belonging to the other race, then the matter proceeds. Now, I think it's a question of allocation, that in the allocation of cases, it should not be known as to who's going to be presiding, in order we can avoid that forum shopping, in my view.
Thank you. I will now give the opportunity to Ms. Stewart. If you have questions for the candidate, this is the opportunity.
Thank you, Acting Chief Justice. Dr. Lekhuleni, I have two questions for you. One of them is personal and the other one is a general legal question.
Yes.
Your CV says you went and did a stint as a military judge, and I'm just interested what caused you to do that. It's quite an unusual step. Okay, how did you find it and why did you do it?
Look, I was still practicing as an attorney when I went to be a military judge. I wanted to exercise judicial discretions. And unfortunately, I never had the opportunity of exercising judicial discretions. And when I saw that there was a post of a military judge in the army, a reserve force post for a military judge, I thought that this was an opportunity that I should grab with both hands, and I went to study military law. And over and above, I'm a committed citizen of the country who also wants to ensure that there is discipline also in the army. As you know, that in terms of Section 200 of the Constitution, we need to have an army that is very much disciplined, so that in times of war, they can defend us. That's one of the reasons why I also went to study military law and became a military judge.
Thank you. And my second question is, it relates to the distinction between a review under PAJA and a review under the principle of legality. I see that you have done a review in your CV. You say you've done a review under Section 6 of PAJA.
Yes.
Can you explain for me how you understand the difference between a review under PAJA and somebody who brings a review under the principle of legality, and why we have that distinction?
I'll try to explain that also based on case law. Section 6 or PAJA, when you look at it, it's giving effect to a right in the Bill of Rights, which is Section 33 of our Constitution. Whilst a review in terms of the principles of legality, it's based on the common law. Now, the Constitutional Court has made it very clear that an organ of state, let me put it this way, the Constitutional Court has made it very clear that Section 33, a review in terms of Section 6 of PAJA, which is giving effect to Section 33 of our Constitution, it's applicable to private individuals and not to organs of state where they're applying for review of a decision of their own decisions, because they are the bearers of obligations. Now, if they want to make an application for a review of their own decisions, they have to do so in terms of the principle of legality, which is based on the common law. Whilst a review in terms of Section 6, it's statutory. It's based on the statute. And I was just referring to you to the case of Sita versus Mgijima Holdings. That's where that principle was raised. I don't know whether I answered your question.
Acting Chief Justice, that's perfect. I don't have any more questions. Thank you.
Thank you.
Thank you very much. Commissioner Moiman.
Thank you, Acting Chief Justice. Good afternoon.
Good afternoon, Commissioner.
Just educate me on one of the areas that has been on the table of Parliament on two issues: whether to have a ballot, whether to have an open ballot, start a motion, or a secret ballot. Can you just educate me in the latest case that you had?
Yeah, look, it was an ATM matter, I think you must have seen. I must say that it was a very complicated matter, and it raised the constitutional issues because it dealt with Section 102 and Section 167 4E of the Constitution. I don't know. Do you want me to just to explain to you about the secret ballot or not? Maybe let me put it this way. In that case, briefly, the Speaker of Parliament made a decision that the secret ballot, which was tabled, rather no, the motion of no confidence, which was tabled by ATM, was going to be heard by open ballot. And ATM was not happy with that. They brought an application to review that decision, saying that the Speaker was wrong in his decision to decide that the motion of no confidence against the President should be held by open ballot, especially taking into account the decision of the Constitutional Court in the UDM matter. But what happened in that case was that the jurisdiction of the High Court was impugned, in a sense that they said that the High Court does not have jurisdiction to deal with matters arising from Section 102, because in terms of Section 167(4)(e), it was a matter that falls exclusively within the jurisdiction of the Constitutional Court. And I must say that when I read case law and I realized that the Constitutional Court left that question very much open in almost 3 cases, whether the High Court has jurisdiction to deal with a motion of no confidence in terms of Section 102 of the Constitution. But after considering the matter, I realized that I found that the High Court does have jurisdiction to deal with a motion of no confidence against the President. In this case, in the sense that, because the argument was that when the Speaker decided to order that the motion of no confidence against the President should be by open ballot, it was Parliament having failed to fulfill a constitutional obligation, triggering Section 167(4)(e), the exclusive jurisdiction of the Constitutional Court. And I said, no, that cannot be. Because it cannot be that when a Speaker of Parliament decides and or rather makes an irregular decision, then we can say that Parliament has failed to fulfill a constitutional obligation. It was on those bases that I said that the Speaker exercised his right. In any event, in terms of Section 59 of our Constitution, the business of Parliament should be open. And the Speaker was right in a decision. Maybe something that I can also indicate, which I think was very much of interest to me, was there was a question as to whether does a person who, let's say a party that presents a motion of no confidence in Parliament, does it bear the honors to prove to the Speaker that it should be the procedure should be by secret ballot, or it should be by open ballot? And I found that no, look, as I said, there is no honors. There is no honors as far as that is concerned. The only question.
Thank you, Advocate Kikorovile. Thank you, Acting Chief Justice.
Thank you.
Thank you.
Commissioner Amatolo Zepu.
Thank you, Acting Chief Justice. Good afternoon, Dr. Lekhuleni.
Good afternoon, Commissioner.
Mine is just a simple one. You seem to be very energetic, very. But I just wanted to find out from you. You became you were practicing on your own account from 1999 to 2004. At the same time, you ventured into that military judge issue. But I just wanted to know what made you leave private practice before to go to the magistracy?
What made me?
What made you leave private practice?
Yeah, look, as I said, I think I tried to explain that from the beginning. It was my desire to exercise judicial discretions, and I cannot do so as an attorney. That is why when I was practicing as an attorney, I went to study military law because I saw a position of a military judge, and I applied and I was taken. And I then was appointed as a reserve force military judge. And as a reserve force military judge, I had an opportunity of exercising my judicial discretions without fear, favor, or prejudice as entrenched in Section 165 of our Constitution.
What do you mean you wanted to exercise judicial discretion?
Yeah, judicial.
Let the candidate explain himself, please.
Yeah, well, I think they've already said it. The judicial power to decide, to decide the case It's a judicial discretion, yes.
Okay. No. There's nothing wrong with wanting to exercise judicial power. There's nothing wrong.
Yeah, it's a bit too strong.
It looks like there are no questions. Let me check with the. Oh, there are still. Oh, yes. Judge President Mlambo.
Thank you very much, Acting Chief Justice Doc. Good afternoon.
Good afternoon, JP.
The Magistrate Lekhuleni in Mpumalanga, are you related to him?
Magistrate? No, I don't think I may be with our fathers, but I'm not aware. I don't know him. Thank you.
Okay. When you were a reserve force military judge, did you have a rank?
Yes.
What was your rank?
I was a lieutenant colonel.
Oh, okay.
I was a lieutenant colonel.
Okay.
JP.
That means we have to salute each other.
Yeah, you have to salute.
Thank you very much, Acting Chief Justice.
Thank you.
Since you're already a judge, why do you want to be another judge?
I want to exercise judicial discretion at another level.
Thank you.
Commissioners on the. Commissioner Schlemmer. Oh, I wrote you down. Yeah.
Thank you, ACJ. Dr. Lekhuleni, I would just like to know from you, what is your judicial philosophy when you exercise your judicial discretion?
My judicial philosophy is fairness and justice, which derives its authority from the Constitution. I believe that we need to start from the Constitution. If you are sitting in a criminal court, you have to start from the Constitution because you are dealing with Section 35(3) of the Constitution. When you are sitting in a civil matter, you have to still start from the Constitution because you are dealing with Section 34. And I believe that when you are interpreting any legislation, you have to look at the provisions of Section 39(2). When you are dealing with the interpretation of any Bill of Rights, you have to look at Section 39(1). Now, it is on those bases I say that my judicial philosophy is constitutionally inclined. Thank you.
Thank you. Actually, I think Commissioner Schlemmer is right. You are Dr. Lekhuleni. Yeah, you have earned it. You have got your doctorate.
Yes. No. Thank you. Thank you, ACJ.
Now, during your acting stints in the High Court, did you do criminal trials and civil trials? Did you do both of those?
Yes, and I'm very much thankful to the JP of the Western Cape because he exposed me to criminal trials, he exposed me to civil trials. In fact, I can also indicate that I'm faced with a matter which involves 20 accused persons who are facing 145 charges. In fact, I'm busy with that matter currently, and I was informed that almost 250 witnesses are going to testify that, but I expect that maybe by the end of term, I will have made inroads in that matter. I've dealt with also with the civil trials as well, and I've written judgments in civil trials as well.
And have you also done motion court?
Yes, I've sit in motion court. In fact, the practice in the Western Cape is that at least in a week, the whole week in a term, you have to sit in the motion court.
Yes.
I've sat in the motion court almost all the terms that I sat in the High Court.
Yes.
Yes.
Thank you. Commissioner Pofu?
Yes. Good evening, Dr. Professor.
No, Mr. Lekhuleni suits me fine too.
What they call modesty will not get you. And anyway, I want to ask you about that. Do I understand that you have an LLD already?
Yes, I have an LLD.
And you also have a PhD? Or are you doing a second doctorate?
No, I did an LLD and then I'm doing a master's in international criminal law.
Oh, I see.
Yes.
Okay.
He's doing a third LLM.
Yeah. And towards another doctorate. Okay, thank you. All right. No. Look, I think I will not ask you a content question because it's clear. So I just wanted to ask you if there's, particularly with the division that you are applying to,
Yes.
there are some serious challenges of transformation, probably more than anywhere in the country. Is there a particular reason why you applied in the Western Cape? And linked to that question, what has been your experience acting in that court around the issues that I've just raised?
Yeah, look, the reason I applied for the Western Cape, I've been in the Western Cape since 2004 when I was appointed as a magistrate. I have a house, my family are there, my children are there, attending university there. And it is for those reasons that I applied in the Western Cape. Yes, I agree with you that there are dynamics in the Western Cape, and there are those issues that I think we need to deal with them head on, and we need not sugarcoat them. Yes, we need to attend to that. Yes, I choose to be brief, and I don't know what I answer your question.
No, it's fine. It's understandable.
Yes, no, thank
I
you.
would answer like that if I was from the Western Cape.
Yeah. Yes, thank you.
Dr. Lekhuleni,
Yes, thank you.
what is your understanding of a misdirection by a lower court when you are sitting on appeal?
Yeah, a misdirection of the lower court may happen where the lower court made a finding on the facts which conflict with what was presented, made an incorrect finding on the facts that were presented, or and made a finding on an incorrect application of the law. For instance, where there are substantial and compelling circumstances in a murder case, and you find that the court did not depart from the prescribed minimum sentence. In that event, that's a misdirection. In other words, or making a finding which is not supported by the facts. Yes.
Thank you. I think we have come to the end of this interview. Thank you very much. I already gave the commissioners on the virtual platform, I think. Thank you very much for making yourself available, Dr. Lekhuleni. We appreciate it. You are now excused.
Thank you very much, ACJ, and thank you very much to the commissioners. Thank you.